good morning, good afternoon, or good evening, depending on where you are in the world. And welcome to Finnegan's webcast, Trade Secret Protection for AI Innovations. I'm Marta Garcia, and I'll be your presenter today, or moderator today. It's my pleasure to introduce our presenters, Arpita Bhattacharya, Rob McCauley, and John Williamson. Arpita is a partner in Finnegan's Palo Alto office and focuses on patent litigation, PTAB work, and client counseling. She has an undergraduate degree in electronics engineering and a PhD in biomedical engineering. With her technical experience, Arpita advises clients on various emerging technologies, including AR, VR, AI, and digital health. Rob is co-leader of Finnegan's Trade Secrets Group. He practices patent, trade secret, and trademark litigation. Rob is a former deputy district attorney and has first chaired more than 30 jury trials and more than 50 bench trials. John is co-leader of Finnegan's litigation section. He's a seasoned patent and trademark trade secret attorney with more than 20 years of litigation experience. His experience spans a wide range of technical areas, including robotics, software, and medical devices. Before I turn things over to our presenters, I invite everyone to participate by submitting questions. This is an interactive webinar, so just click on the Q&A button at the bottom of the webcast interface and type your question into the Q&A window and then click submit. The questions will be answered today during the Q&A section, which will take place at the conclusion of the presentation. You can enlarge the slide window at any time by clicking on the Enlarge Window button on the top right side of the slide window. The slides will also advance automatically throughout the event. And if you experience any technical difficulties, please just click on the Webcast Help Guide button in the lower center of the webcast interface. And now I'll turn it over to our presenters to begin our presentation, Trade Secret Protection for AI Innovations. Welcome, Arpita, Rob, and John. The floor is yours.
Thank you, Marta. I am going to start us off with the discussion of patents versus trade secrets for protecting AI innovation. So with ChatGPT becoming the latest sensation in tech, everybody seems to be super excited about AI and how AI has the potential to revolutionize not just high tech, but also life sciences, e-commerce, banking, etc. But ChatGPT is only the newest addition. AI has been around for much longer and has already infiltrated our lives. Even when you are simply opening your iPhone using Face ID, or you are doing a Google search or using digital voice assistant like Siri, Alexa, or Cortana, you are using some form of AI. But what really is AI? People often use terms like machine learning, deep learning, artificial neural networks, etc. interchangeably, but these are just different types of AI. At its basic, AI is enabled by complex algorithms that are designed to make decisions, solve problems, and perform tasks that require human-like perception, sensing, and thinking. More understand the idea of an overall AI system, example, a robot. However, it is necessary to understand the more specific components that make an AI system in order to better protect it. For patent applications, the USPTO defines AI as comprising one or more of these 8 components shown on this slide. These components span software, hardware, and applications, and a single patent document may contain multiple AI component technologies such as machine learning, natural language processing, etc. So if you think of an AI system as the forest, these component technologies are the trees that make up the forest. But beyond the definition and components of AI, when it comes to IP, it is best to think about the different AI invention categories, how to best protect them, and where does your company's AI innovation fall in this chart? although the use of AI is becoming really widespread, you can still distill AI inventions into these three distinct buckets. And knowing which bucket your invention falls in can help with deciding what form of protection, patents, trade secrets, or combination of both is needed to protect that invention. The first category is advancements to AI itself. Example, a new machine learning model, a new neural network structure, etc. These are the algorithms powering your AI tools. But as you're probably familiar with Section 101 and the hurdles posed by Ellis in getting patent claims to pure algorithms. So a pure algorithm, which is likely going to be a series of mathematical steps, may be difficult to patent by itself because it's likely going to be considered an abstract idea. Patent law is not a friend of algorithms by themselves, as you all probably know. So this is where trade secrets can come handy. As long as you can maintain secrecy of your algorithm, you can protect it as trade secret. The next category is applications of AI. That is inventions that apply AI for other tasks. For example, a method of detecting a new biomarkers using AI. Chatbots such as ChatGPT are also a good example of an application of AI. Now, even though pure algorithms may not be patent eligible, claims to an AI application, when drafted as a system claim or a method of use claim, can be patentable. And you can even get patent claims on how to train your AI system. And in fact, in the USPTO's guidelines on Section 101, they provide an example of a claim on a method for training a neural network for facial recognition. According to the USPTO, this claim is not directed to an abstract idea and is eligible for patenting. Here's another example of a patent on an AI-based system for medical image reconstruction. This claim, for example, is directed to a deep learning system, and it passed Section 101 muster during prosecution. So even though a claim to an AI-based system may still face some Section 101 challenges, it is possible to get claims for AI systems. It really depends on how you draft the claims and how it is prosecuted. Now, going back to this prior slide here, not everything about your AI system is, however, patent eligible. For example, the data sets used for training or specific weights for the algorithms, other mathematical relationships, those cannot be protected, patent protected. So for those, you may still consider trade secret protection. And this is where you have to really strategize about what to patent and what to hold back as trade secrets. So just to emphasize, for AI systems, you can use a combination of patents and trade secrets to fully protect it. And the third category is inventions generated by AI itself. Example, new drug design, code written by generative AI tools like ChatGPT, GitHub Copilot, etc. If, for example, a rogue engineer in your company is using ChatGPT to write code or come up with an invention, whether the output generated by the AI can be patented or whether it can be protected as trade secret, however, is questionable. Theoretically, you can get a patent to the output of an AI, but for the inventorship concerns. If the invention is generated by AI and not a natural person, you may not get a patent to it because of lack of inventorship. And I'll delve into this a little bit more shortly. And as to trade secrets, again, theoretically, you can protect the output of generative AI as trade secret, but practically it may be difficult if you are using off-the-shelf AI like ChatGPT. It would depend a lot on confidentiality terms of ChatGPT. And I believe John will touch on the confidentiality requirements later, so I won't get into that right now. But suffice to say that ChatGPT has rights to use both your input and output as training data for further improving their algorithm. So if that rogue engineer in your company is using your company's confidential information as input, that confidential information could become training data for ChatGPT. And the output that ChatGPT generates for some other third party may include or closely match your confidential information, because with generative AI like ChatGPT or Copilot, the output often closely resembles the training data. So there is a significant risk of using off-the-shelf generative AI like ChatGPT, Copilot, etc., for developing your company's proprietary code or other products. Now, I had mentioned that AI systems can be protected through patents as well as trade secrets. Here are some of the pros and cons of patents versus trade secrets that you may want to consider in deciding what path to take. With patents, you have a right to exclude others, and you are also protected against independent development or reverse engineering. However, you may want to consider that patents are not guaranteed. So if you disclose an invention in a patent application and it gets published, but later you do not get a patent, then you cannot turn around and decide to keep something a trade secret because the disclosure has already been made. With trade secrets, on the other hand, if someone else independently comes up with the same invention or reverse engineers it, you have no recourse. And this can be particularly problematic with off-the-shelf generative AI such as ChatGPT, where others can provide similar inputs into the AI tool and independently come up with the same output as your invention. Now, if someone misappropriates your trade secret, you will have a claim against them, but otherwise you will have no recourse. Another downside of trade secrets is that you have to be vigilant about constantly maintaining confidentiality, and this can sometimes interfere with your business objectives and the need for disclosure and collaborations. But when it comes to AI, trade secrets offer some additional benefits that were not listed on my prior slide. For instance, some features of AI, such as pure algorithms, the training data, weights, etc., are not patent eligible. So trade secrets are a good way of protecting them. Second, for inventions that are generated by AI, there is a concern about inventorship, as I mentioned previously. You may have heard about the Taylor v. Vidal case from last year, where the Federal Circuit rejected an attempt by researcher Stephen Taylor to name an AI machine that he created as the inventor on 2 patents. And while the Federal Circuit's ruling on the Taylor case provides clarity that an inventor has to be a human, it leaves open the question of what level of reliance on AI in the invention process would deprive a human from claiming inventorship. There's still a lot unknown about how the line drawing should be done between AI as an inventor versus use of AI in invention. Just this week, I believe on Valentine's Day, the USPTO released a notice to the Federal Register asking for public comments on AI and inventorship. The PTO's call for comments seems to be a good step towards determining the legal contours of AI and inventorship, but whatever the PTO recommends will still be litigated. So until there is more clarity on these issues, I suggest practitioners use caution on this inventorship issue. And last but not least, maintaining an invention as trade secret may be less expensive than filing patents on the many iterations in the development lifecycle of an AI-based system. Not every version or iteration will be commercialized, and it is often hard to tell during the development process what will make the cut. So maintaining everything as trade secret might be more cost effective in the long run. Another thing to consider is that there are often multiple players involved in an AI invention. One party may develop the model, another may train the AI model, and yet another party may provide the data to train the AI model. So inventorship, ownership, and trade secret protection for an AI invention can often become a can of worms. But many of these issues, particularly ownership and trade secret protection, can be resolved through careful contractual agreements between the many actors, which John is going to discuss. What I want to emphasize here is that a lot of the concerns regarding ownership and trade secret protection center around the use of off-the-shelf AI solutions such as ChatGPT, Copilot, etc., where you have far less control over confidentiality arrangements. If a company develops or licenses customized AI technology or licenses specialized data sets to train the AI, then it is much easier to maintain trade secret protection among the multiple actors through confidentiality agreements. And in such situations, the main concern with trade secret violation comes from employee mobility, which Rob will discuss in more detail. So when it comes to off-the-shelf AI, you have to carefully consider what data is the AI trained on. Often chatbots such as ChatGPT are trained on publicly available open source data. So if you use ChatGPT to write code for your company, there's a good chance that your proprietary code may be tainted by open source code, because as I mentioned previously, a lot of the generative AI tools will often spit out exact or very similar copies of the open source training data, which then calls into question whether that output can be protected as trade secret. So you have to be very careful when using off-the-shelf AI tools. And the last thing I want to mention before I hand this over to John is that AI technology is unsettled, and so is the law surrounding it. There are no clear-cut answers to many questions regarding AI. So if you choose to use generative AI tools such as ChatGPT, etc., for writing code or for other purposes, you should carefully consider the cost savings from using AI versus the potential risk of not being able to protect your company's IP. And with that, I'll hand it over to
Two
John.
questions for you, Arpita, before we transition over to John. The
Sure.
first, you had mentioned that if publicly available data is included in the training data set of AI, it could pose some risks for trade secret protection. How about open source licenses for software development? If open source code is used to train an AI programming tool, could it then affect either patent or trade secret protection?
Good question. And the short answer is yes. Here's the long answer. So generally, the AI model underlying a code generator, for example, Copilot, is trained using open source code that is available in public code repositories under open source licenses. And some of these open source licenses could be a copyleft license, example GPL, which places limitations on how code developed using the open source code is distributed for use. So if open source code makes its way into your company's proprietary code, the license of the open source code may then get applied to your proprietary code, requiring it to be released under the same open source licensing terms. And because AI code generators are known to recommend copies of training code, there is a risk that the license of the open source code may get applied to the code developed using AI. And this may limit your company's ability to obtain and enforce IP rights. Although some of these risks can be averted by manually reviewing the code or using automated code scanning tools, but none of the scanning tools are 100% guaranteed to catch all open source code. I hope that answers the question.
second question. So then if open source license code is reproduced as generated code by a generative AI tool, is there also a risk of copyright violation then?
Yes, there is the risk as well, particularly because a lot of these AI code generators often do not follow the open source licensing terms such as attribution. And so, and even if the auto-generated code includes a somewhat modified version of the copyrighted source code, it may still be considered a derivative work that is protected under the copyright of the original code. So I would say, yes, there is the risk of copyright violation.
Thanks. And with that, I think we can turn it over to John.
Okay.
Thanks, Marta. Thanks, Arpita. From here, we're going to cover some high-level concepts regarding trade secrets in particular, protecting trade secrets in the what we'll call the AI ecosystem. We'll begin by returning to sort of first principles regarding trade secrets, a very quick overview of what trade secrets are and what misappropriation entails. And then we'll see those principles applied in 3 AI-related case studies. And finally, building on those case studies, we'll then look at kind of the AI ecosystem more generally and identify what types of information might potentially qualify for trade secret protection and where and how those trade secret issues could arise. So to begin with, there are many different sources of law for trade secrets, including, for example, U.S. state law, U.S. federal law, common law. There's an international treaty, the TRIPS Treaty, the EU directive, and implementing national legislation for that directive. And there are differences and nuances across the various jurisdictions, but really distilled to their essence, trade secrets are kind of defined by the 3 requirements we see here. And this is more or less common in all jurisdictions that recognize trade secrets. First, trade secrets are information. That's a very broad category, but that's what they are. They're just information. The information has to be secret. It's not known to others. It's not easily determined publicly from public information. Second, the information must have economic value by virtue of the fact that it's secret. And third, the information must be subject to reasonable measures to maintain its secrecy. And so examples, really fundamental measures that are going to include things like virtual and physical security, employee education, and the use of non-disclosure and non-use agreements. So those are reasonable measures. This reasonable measure standard, it is very fact and circumstance specific. There's really not a one-size-fits-all list of measures that if you take these, you're guaranteed to satisfy the legal requirement. Rather, what we see are courts that consider the facts and circumstances of each case, the sensitivity of the information, the size and the resources of the party that's protecting the information, the nature of the conduct that's at issue in the litigation sometimes, and other fact-specific inquiries that courts will look at in determining whether reasonable measures have been taken. So sometimes it's a difficult standard to apply, and we'll see how it plays out in some of our case studies here in just a moment. Turning next to misappropriation, the statutory language for misappropriation is a bit unwieldy, but the concepts are relatively straightforward. The statutes tend to focus on 3 activities: acquisition of information, disclosure of information, and use of the information. So anyone who acquires a trade secret by improper means is going to be liable for misappropriation. Anyone turning to disclosure or use, anyone who discloses or uses a trade secret in violation of a duty to maintain it in confidence, so an NDA, for example, or fiduciary duty, If you violate a duty to maintain it in confidence, then you can be liable for trade secret misappropriation. And anyone who discloses or uses a trade secret knowing or having a reason to know that the information was acquired by improper means is also liable for misappropriation. And when we talk about improper means, we see some examples here of activity that's improper, such as the breach of an NDA, and some examples of activity that is not improper, such as reverse engineering. So these kind of basic principles, the definition of trade secrets, the standards for misappropriation, they're going to apply in the AI context the same way that they would apply in any other context. As we'll see, AI is interesting because it's unique because of the types of information involved and the types of issues that might be presented. But the law is no different for AI than it is for anything else. So with that, I'll turn to our first AI-related case study that we have here. It's a case called LivePerson from California. And here the plaintiff in this case, LivePerson, operated a digital platform that website operators could use to determine the best time to initiate a chat conversation with a user of the website. So it's going to monitor and analyze things like an end user's interaction with the website, navigation history, which pages in a website they have gone to, specific time spent on certain pages, the way they're interacting with a shopping cart, for example. Those types of interactions are going to be monitored. LivePerson is then going to develop predictive rules for initiating chats that are going to be most likely to lead to a sale or an account opening or some positive result. So the technology addresses really when and where on a customized website do you initiate a chat. Each of LivePerson's customers are going to have their own customizations and rules and objectives for the platform. And each customer is going to generate data that's then fed back into the platform that LivePerson can use to create better rules and improve their platform for that customer. So that's LivePerson's business. The defendant in the case is a company called 24/7 AI. They operated what were known as digital chat agents. So they're the technology that's actually doing the chatting. They partnered with LivePerson here so that the two companies together could offer both the platform and the chat agents to their customers. Now, as part of this partnership, 24/7 AI gained access to LivePerson's customizations, to its rules, and to its data for three specific LivePerson customers. One of them was Optus, which is a mobile phone and telecommunications operator, Capital One, which is a bank, and then Sears, a traditional retailer, online retailer. And so those are the customers at issue. 24/7 AI subsequently develops its own competing chat platform with the benefit of the data that it has access to, and takes all three of those customers from LivePerson. So LivePerson sues for trade secret misappropriation and establishes that the data sets at issue here were the trade secrets and that 24/7 misappropriated that data. And the opinion in the case, it doesn't mention the machine learning or the algorithms that are actually going on or being used by LivePerson to improve its platforms, but rather the case seemed to be focused on the data, the rules, and the data that the specific customers used and generated. In the course of its case, LivePerson needed to rely upon its confidentiality agreements with its customers to show that it protected the confidentiality of the data at issue. And it's a primary issue in lots of trade secret cases. It was certainly a primary issue in this case, whether LivePerson has taken appropriate measures to protect the data that's being generated by its customers. Whether its confidentiality contracts with its customers were good enough to impose a duty of confidentiality over that data such that it can be maintained as a trade secret. This case was tried to a jury. The jury decided that the agreements were good enough, and in post-trial motions, the court agreed. So this is a very common application of an AI system that we see here, where data is being generated, fed back into a system for learning, improvement, and optimization. And from this case, we can see and appreciate that when an AI provider is working with anyone else, customers in this case, partners in this case, it's extremely important to understand who owns the data that's going to be generated and is at issue, and to establish confidentiality obligations regarding that data. So moving to our next case study here, this is the GLE scrap metal case. In this case, the defendant, Mr. Tan, was a former employee of a company called GLE Scrap Metal. His job was to connect buyers and sellers of various types of scrap metals. So specifically, he is using sellers' photographs that they send in of their scrap metal to identify the metal, the type of metal, its volume, and to estimate a price. And then he's trying to find and match buyers for that particular scrap metal. In the course of his work, he used pricing strategies and formulas that were owned by the plaintiff as well to value that metal. Eventually, Mr. Tan told his employer essentially that he thought AI could do his job. So he was going to leave his employment, develop AI to perform his job, and commercialize the AI application. And he did that. He left his job. Mr. Tan's wife actually developed an AI app that could analyze and classify photos of scrap metal. So it has an image recognition and machine learning component to it. And it would also estimate prices, and it could link sellers and buyers through a trading platform. They called this app Dr. Scrap and began to market and promote it as an alternative solution to what GLE Scrap was providing. The plaintiff in the case filed an immediate suit for trade secret misappropriation, claiming that the images that were used to train and build the Dr. Scrap application were taken from plaintiff's facilities or its customers' facilities, that they were private, and that the app also used plaintiff's proprietary pricing information. And GLE obtained a temporary restraining order right out of the gate, enjoining Mr. Tan from marketing and selling his new application. But at the preliminary injunction phase of the case, at that hearing, the court found that the plaintiff in the case actually failed to show likelihood of success on the merits, because it couldn't show that the pictures that were used to develop and train the AI were in fact pictures that were exclusively available to the plaintiffs, as opposed to pictures available publicly on websites, or other parties had rights to the pictures or anything else. Plaintiff couldn't show that they were exclusive to the plaintiff's rights, basically. And the plaintiff, same for the pricing information, failed to show that the pricing formulas used by the app were the plaintiff's rather than publicly available online scrap metal resources. So at that point, the court denied the preliminary injunction, dissolved the TRO, and the primary reason for this centered on the public or perhaps quasi-public nature of the data that was used to develop the AI. There was no evidence in this case of confidentiality agreements or anything else protecting the confidentiality of those pictures and other data used to train the AI, as we saw in the live person case study. And finally, the third case we want to address is called Planner 5D. This company, Planner 5D, started out by offering a web-based service for interior design. So they created thousands of digital files and images representing everyday objects, things like furniture and lamps, fixtures, and then they allowed users to choose those objects and place them and manipulate them in rooms to create 3D images, digital scenes, essentially interior designs that they could view through their web browser. They claimed, Planner 5D, to have over 40 million unique users of their service, and they had a collection of over 1 million realistic three-dimensional objects and images showing household rooms, offices, and household designs, basically. The company then changed their business entirely. They started to focus on developing AI for computer vision and scene recognition. Planner 5D noted basically that one of the main roadblocks for developing accurate computer vision technology is actually the access to the training data. So they decided to leverage these millions of digital scenes that they had that were created by human designers, configured in very realistic scenes and configurations, leverage all of that to train algorithms for 3D recognition and computer vision. Now, they allege that university researchers at Princeton also recognized the value of this vast data set for training and developing AI. And Princeton found a way to download all of their data. Planner 5D alleges that Princeton created code that intercepted communications to its servers to identify the locations of digital files, and then created code to crawl through thousands of pages within Planner 5D servers to catalog these files and then download them. So once they were downloaded, Princeton then allegedly posted the data set to a publicly accessible Princeton URL and gave it a name. They called it the Sun GC dataset. Facebook then used the publicly accessible dataset for a competition for scene modeling and understanding, a AI competition. As part of this activity, the entire data set was then published on another Stanford University URL this time. And apparently it may have been published and downloaded further by others in the academic and research community. So in essence, Planner ID is alleging that it has lost control over what it contends is an extremely valuable training data set for AI. They brought suit alleging, among other things, trade secret misappropriation. And a first reaction might be, how could this possibly be a trade secret misappropriation case? We're talking about items and images that are publicly available through a web-based service where they've said they have 40 million different users who have accessed the images, manipulated them. It just doesn't sound like something that meets that first prong of secrecy. But here the plaintiff is not claiming that the images and the scenes themselves, the ones that the users interact with, are trade secrets. They're claiming that the underlying digital files, the things that the computers can use for training, and the compilations of those digital files are the actual trade secrets. And they claim that these files are only available on their server at obscure addresses or at best on cached pages of their users' computers. And the compilations were never available really as such to end users. So there's some nuance here in what they're claiming about what seems to be quasi-public data. The plaintiff has survived a motion to dismiss. It took them 2 times, but ultimately they survived when they repled their claims to argue that, number one, their terms of service expressly prohibit web scraping. So the type of activity that Princeton engaged in to gain the information was precluded by their terms of service, prohibited rather, and that they've structured their website such that these digital files are at very obscure locations, URLs that aren't easily guessed and understood. And that was enough. Defendants dispute all of this, of course, but again, it's enough to get past the pleading stage and survive a motion to dismiss and plead a case for trade secret misappropriation as to those underlying digital files. So those are a few case studies. The reality here is that there aren't many trade secret opinions addressing AI yet. We suspect that's going to change at a rapid pace. and that we will see much more activity in the near term. But so far, we have a handful of cases. They seem to center on using trade secret law to protect data sets that are used with AI, and the types of agreements that go into protecting those data sets. Very quickly here, we wanted to just also share a few observations from the cases and from trade secret law generally in the context of a broader AI ecosystem. On the right in this diagram, you can see we've illustrated some of the common types of information that we see at play in the AI space, and we've categorized that information. Obviously, in the middle, there's the AI model, the algorithms, the software, but we also have training data, input data. We have the uses and customizations of the AI models and rules, and that can include things such as the type of input data used, the order the input data is applied or reapplied, the interpretation of the results. We have improvements or customizations of the AI model that come through maybe its use in the wild. We have output data from the system and end user experiences. So you have many of these high-level categories or different sets of information that are involved in this space. And we wanted to illustrate this because theoretically, trade secret law can be used to protect each category of information shown here. Obviously, as Arpita mentioned, if you're using public data sets, that's not going to be protectable under trade secret law. Or if you're using open source, that's not going to be protectable under trade secret law. But in theory and in practice, in certain contexts, all of these types of information can be protected under trade secret law. And if you're in a position where you intend to use trade secret law to protect information that's involved in AI development or application, it's important to kind of step back, see where you fit in and the information fits in to the commercial environment, and understand kind of the primary considerations that we've outlined here: the ownership of the information, the permissible scope and uses and access of the information, and most importantly, the confidentiality obligations that the information will be subject to. All of that can be handled and is often handled through the various types of contracts that we saw in our case studies. Some of the specific contractual issues or clauses that we think are interesting from a trade secret perspective in AI are listed here. Prohibitions on reverse engineering. This is something that the owner of an AI model may consider, and it's long been part of software licensing, and we can expect to continue to see it in the AI context as well. AI models that are licensed are likely to and might include provisions that preclude others from attempting to reverse engineer the actual models and algorithms. Prohibitions on web scraping, we've seen that and how they can protect the data sets that might be generated, valuable data sets that might be generated and used in this context. Limitations on the scope of the use of AI models are interesting. Some AI model owners might contractually preclude licensees, for example, from using the AI model as a component in another product or as part of another AI model. So there might be limitations on the scope. Input and output data are often addressed in contracts as well. And really, most importantly, confidentiality. To the extent that you intend to both share information with others deliberately and maintain trade secret protections for that information, you really must ensure that every party that receives the information is under a confidentiality obligation. And that's going to include partners and customers and, importantly, employees. And with that, I'll hand it over to Rob to kind of talk through some employee-specific issues that go to confidentiality as to the employee relationship in particular.
Thank you, John. I'd like to pick up where you left off on this confidentiality notion. And this is a subject of another webinar that we sometimes give. and advice that we sometimes give to clients. But a lot of clients use old NDAs that have been sitting around in files that have been reproduced a million times so that you can hardly even read them sometimes. Back before almost the time when people were using carbon paper. I mean, some of these things are so old and they really should be updated. It's one thing that you really ought to do is just ask somebody to update your standard NDAs to the extent you have one and have lawyers look at them. What I'd like to do for this last segment of today's discussion is focused at least first on employee mobility and non-competes. So I'm going to take up the confidentiality baton that John just passed to me and discuss that. Employee mobility and confidentiality has always been a significant issue, but we think it's going to become an even bigger issue, an even more significant issue as AI becomes more and more pervasive across all kinds of industries. And turning to my next slide here, I'd like to talk about the FTC's proposal to outlaw non-compete agreements. I won't go into that in any detail other than to say the obvious. The FTC is proposing to ban non-compete agreements, and that proposal is up for public comment. The FTC doesn't think that non-compete agreements are good for employees. It doesn't think they're good for society. And you can see this image here on the slide. This was from a CNN interview that actually occurred earlier this week. I was looking for some timely content, and here it is. Mr. Smercornish, the host on the left, was interviewing a director at the FTC about the FTC's proposal. And the FTC director pointed out the FTC's view that non-competes and eliminating non-competes more specifically will help benefit employees and raise salaries and have benefits along those lines. And Mr. Smercornish pointed out, well, aren't non-competes a good idea to protect companies' trade secrets and intellectual property because it's valuable and people invest in that? And in my view, well, let me first say her answer was no. She didn't think that non-competes were necessary for that at all, which I guess is not surprising. She was also fairly dismissive of the question, in my view, and she pointed out that non-disclosure agreements and trade secret law were perfectly adequate to protect companies and employers in that regard. And I'd like to say that my own view is that's sometimes true, but it's not always true. And I've represented both plaintiffs and defendants in situations like this. I practice in California, where covenants not to compete have long been unenforceable. The doctrine of non-disclosure has long been rejected in California. That's just the lay of the land out here. And not too long ago, I was working with a client who had a group of key engineers, key employees, pick up and go move to a stealth competitor. It was a startup that was in stealth mode. And the client, the former employer, was very concerned that these key employees might be using trade secret information, proprietary information, the crown jewels, the secret sauce that they learned while they were employed with their former employer, and using it for the benefit of some product that was being developed by this stealth competitor. And the problem in that situation was the client had no idea whether this was occurring or not, whether there was misappropriation occurring or not. And NDAs didn't necessarily make him sleep better at night. And I can explain why in a minute. In this situation, a covenant not to compete would have given him much more assurance, although it's much more restrictive on employees, obviously. And today, our client still doesn't know whether the client's trade secrets were being misappropriated or not by these employees when they moved over. So here we have a graphic of a departing employee running for the door and some employee mobility concerns. And this slide really highlights some of the reasons why NDAs are often not or can often not be helpful, enforceable, that sort of thing, because employees very often don't appreciate the value and the confidentiality of what their former employer taught them. I'm always reminded of a case that we worked on here where we represented a manufacturer who over years of time had developed a proprietary manufacturing method that involved off-the-shelf machines, big machines, expensive machines, but off-the-shelf machines that were made by big companies. But those machines were put in a certain order. They were calibrated in certain ways at certain temperatures with very distinct parameters that created a manufacturing process that was very valuable and very secret. And this outgoing employee knew all of those specific parameters and all of those specific temperatures, et cetera. And this employee was under the impression that because all the machinery that they had used was publicly available and because all of their patents had expired, that he was free to go to a competitor and share everything he knew about the manufacturing parameters, et cetera, with the competitor. And in fact, he mentioned this during his exit interview. And if he hadn't mentioned that, then the former employer would never have known what his intentions were. And he might have gone off and joined this competitor and left this other client in the same condition that I mentioned earlier, where he had no idea whether his trade secret information was being misappropriated or not. So NDAs don't fix everything. At least that's my view, and that's certainly the view of the former employers that I'm talking about here. And trade secret doctrine, trade secret law has its limitations. So the final point I'd like to make on this slide is an exit interview is not the time, it's no time to start educating an outbound employee about the importance and the confidential nature of what he's learned or she's learned while on the job with you. You should have been doing that all along. And that's the point of my next slide here. Or actually, it's the one after this, but I'd like to point out the obvious. Departing employees can take with them their thumb drives and their brains, and there's a whole lot of information that can be included in those that shouldn't be going out the door. But they also very often forward to themselves personal emails, or they forward work emails to their personal accounts that they have forgotten about when they go through their exit interview, either innocently or not so innocently, and they can access those afterwards after they've gone to work for a competitor. So to say the obvious again, an outgoing employee is putting your confidential information, including the various forms of AI that Arpita and John have described, at risk. So what do we recommend to deal with this reality? What we recommend is that you start preparing for an employee departure from day one. That may seem a little defeatist, but we think it's a good approach, particularly with high-level engineers and people who are going to know about the crown jewels, the secret sauce that your company is putting into play. So the obvious thing is require employee NDAs and confidentiality agreements at the time of hire. I'm not an employment lawyer. I work with them sometimes, but that's when you have the most leverage to get an employee to sign such an agreement. You can also have those updated over time, although I understand that that creates employment obligations and problems, and you had best work with an employment lawyer to make sure if you're doing that, which is a good idea after, say, a decade of employment, to make sure that you're following the law. You also want to have a reasonable trade secret policy and require adherence to it. This is a complicated subject in some ways, but it's also very simple. A good trade secret policy can actually be pretty simple. The key is that you enforce it and that the employees adhere to it, and that it won't be used against you if people weren't following it because it was, for instance, too complicated. You should also have periodic trainings to remind employees about what's confidential in your business. Let them know, be specific, and you can break it down by department. That's a real good idea, because if you're giving a generic discussion of trade secrets to the entire company, you're probably not going to get as specific as you would if you were meeting with people in a particular division or department. Or for instance, if you had met with that employee I described earlier and you said, by the way, all of the settings and parameters on these manufacturing machines, this is all very confidential. This is all very valuable. If that sort of training had been conducted with that employee along the way over the years, maybe the problem that I described earlier would never have arisen. And in the AI context, we're talking about training employees about all kinds of things that they might take for granted, because employees do that. That could include algorithms, software architecture, data sets, training methods, basically everything that John and Arpita talked about earlier. What's another thing that you should do with employees to try to keep a lid on your trade secrets and maintain them in this environment, particularly if non-competes get abolished by the FTC? You should have a very robust exit interview with employees, particularly key employees. And a lot of times, from what I hear, these kind of exit interviews are carried out by somebody in HR. They're kind of pro forma. There's a few forms that are signed. There's a check that's handed over, keys and pass cards are handed over, and the employee leaves. That's really a lot more should be done with that if your business is trading in or developing trade secrets. You should revisit your original employment agreement, NDAs, confidentiality obligations, and discuss them. If there's an important employee, if there's a key level executive or engineer involved, someone who has a lot of dangerous information in his or her head, a lawyer should be involved. And there should be a detailed discussion about the kinds of information the employee knows that has to remain confidential and can't be used at the next employer. For instance, the employee should be told, you can't use this information that you learned here. It's not enough for you to not disclose it to somebody else. You can't use it. That's one of the forms of misappropriation that John just talked about. And another good idea is to monitor an outgoing employee's IT activities and look back in time. There are lots of instances where outgoing employees have downloaded all kinds of stuff or shot things to their Gmail account on their way out the door, oftentimes in the middle of the night. I mean, it's not, if you're trying to avoid leaving a trail, that's not the way to do it, but some employees do it. And you can also advise your outgoing employee that the new employer may need to be contacted just to advise them that essentially that the old employer is watching and that the old employer expects the new employer and the outgoing employee to respect confidentiality obligations. I'd like to talk a little bit about a recent decision here. It's about a year and a half old, I think. It's called Hooked Media versus Apple. This was a decision in my backyard. It came out of the California Court of Appeal. And this was a case where the trial court granted summary judgment for the defendant, Apple, in the case. It was a summary judgment decision of no infringement. The record, as is summarized on this slide here, included some circumstantial evidence of trade secret use and disclosure, perhaps, at or by the new employer. And some of it's listed here. The former employees who went over to Apple were assigned to similar tasks at the new employer. That would raise a red flag for anyone who lives and works and breathes in an inevitable disclosure jurisdiction, but California is obviously not one of those. Then within weeks of the employment, the new employees had produced a detailed plan for a system that was much like that of the former employer. That's in the words of the court. And finally, an expert had opined that the source code for the former employer's system was similar to the source code for the new employer's system. And on that record, the trial court granted summary judgment of no misappropriation. I've read this opinion several times. The leading opinion in the decision, the majority opinion, it's a majority of two justices, they ruled that basically the former employer, the plaintiff, had not shown substantial evidence of any misappropriation under the law and affirmed the trial court. And one of the things that the court said, and there's a lot of things I could say about this case, but time precludes it. One of the things that the appellate court said was that the evidence does not suggest, that the evidence does suggest that the engineers drew on knowledge and skills they gained from the former employer to develop a product for their new employer. But California's policy favoring free mobility for employees specifically allows that. This statement was written in the spirit of California law, but it's actually not a correct statement of California law. For this to be something closer to correct, it should have said drew on the general knowledge that they gained. while they were employed from the former employer. It doesn't say that. And I'm curious about how this decision might actually percolate and be cited in later cases, because it seems to say that anything your former employer teaches you is fair game somewhere else, and that's just not the law in California. This may be a case of bad facts making bad law. When you read the decision, it's pretty clear that the courts were not very sympathetic to the plaintiff. Apple had made what the courts probably thought was a pretty reasonable offer to the plaintiff to buy its entire business, and the plaintiff was basically asking for a whole lot more than that. And so I don't think that the courts were very sympathetic to the plaintiff, and that probably influenced the decision. But I am interested and concerned about this statement for the reasons that I just mentioned. It also goes to show one of the points that John was making earlier. Trade secret cases are very nuanced. They come down to the totality of facts and circumstances, and I'll just leave it at that. The last point I'd like to touch on is this tension between, well, we're out of time, real quick, secrecy versus transparency. There are a lot of people who think that AI should be disclosed completely, that it should be completely transparent to the public, or at least to governing bodies, governmental bodies with oversight of a particular area. And that's particularly true if you're talking about autopilot, like for Tesla, or if you're talking about healthcare, you're talking about lending practices and whether they're discriminatory. People want to look inside that black box. They want to know everything that's going on. And there's a lot of tension there. It's going on right now with Tesla. Don't have time to get into it. But if you work for a company who works in one of these sort of hot button industries that the government is interested in regulating, you really should be thinking ahead that your AI may be subject to some form of regulation. And you ought to be thinking about whether you can disclose certain parts of it, whether you can disclose, for instance, certain outputs, and whether you can give a high level description of what your algorithms do, but so high level that it doesn't disclose the crown jewels, the secret sauce of your algorithms, so that you can appease some kind of regulatory body or the general public, but maintain the confidentiality of your invention. And with that, I'll hand it back to Marta.
Great. Thank you so much, Rob. I think we have time for just one question, but before we get to that, a quick note, if you could please take a moment to complete our brief evaluation survey. We would greatly appreciate any input that will help us with helping guiding our future programs. So the one question to end on, if our presenters could please comment on why we should be viewing AI trade secrets any differently than other trade secrets we manage, and any takeaways.
I can give my view, and John and Rob can chime in. I think for AI, trade secrets become more important because, first off, there are so many aspects of AI that are not patentable or patent eligible. So you may have to rely more on trade secrets to protect some aspects of your AI, which is not always necessary for other types of invention. And secondly, I would say that just because of the nature of AI, there are so many different actors that are involved in the process of developing an AI invention. There is the one party has the model, other party has the data, and so maintaining everything in that ecosystem can be challenging. So you have to really think ahead on how you're going to maintain the confidentialities and trade secrets. So I think in that respect, AI it becomes different from other inventions where you can put them more in silos.
I agree with that.
I would agree.
Go ahead, John. I'm sorry.
Thanks, Rob. I would agree with everything Arpita said, and just note, I mean, as I kind of mentioned, the law is the same in AI as it is in traditional manufacturing, as it is in drug development and research and any other industry. AI is interesting because of the context, the commercial context that we're in. We are in an environment in which information must be normally shared in order to unlock the value of AI, the data set needs to be shared with the model developer, and the output is going to be used in some respect. And so when it's not like this is the Coca-Cola formula that you can just lock it into a vault and it's valuable because it's not known. You have a situation where you need to operate and figure out how to share your information. And because of that, and because the technology itself is developing new technology, developing new content, because of that, clarity has to be established amongst the commercial actors as to who owns what, who has the rights to use and access what, and who has the obligations to maintain things in confidence. And it's the focus that needs to be put on those three things that are going to dictate whether, at the end of the day, trade secret law is available to you.
Well said, the both of you. You covered everything I was going to say.
Wonderful. Well, thank you so much, Arpita, John, Rob, and thank you all for attending today's webinar on trade secret protection for AI innovations. This presentation will be available on demand in the next week, so please look out for an email from us with the access link. This concludes today's webcast. Thank you so much for participating. Take care. Bye-bye.
Thanks, everyone.